for the formalities prescribed by law for both notarial and holographic wills. Okay. The first rule we have to take up would be Article 804. We do not have oral wills. All wills must be in writing. Okay? The law does not specify the material to be used. In the case of a holographic will, any material may be used. You may write your holographic will on, of course, a piece of paper. You can write it on the ceiling. Gusto mong gayahin si Michelangelo. You can write it on a wall. You can write it on a whiteboard. Anything. Pwede mo. To use an extreme example, you can even write it sa balat ng pakwan. Yung balat ng pakwan. Lagay mo doon. Everything to so and so. Date, sign. Valid yun. Okay? And I always remember that case which happened in I think it happened in the US, where there was a farmer, he was tilling his farm, he was using a tractor. Okay? Perhaps the slope was just too much. The tractor overturned, and the poor farmer was pinned down. Can you imagine how heavy that was? Buong tractor, naipit siya doon. He realized he was dying. What he did was he got a sharp object and he scratched on a metal part of the tractor. Everything to my wife. He placed a date and he signed it. That is a valid holographic will. Okay? Not only must the will be in writing. Of course, we have had such great advances in technology that at present, practically every household has a video cam or a video camera. Even then, it's not permissible for a person to simply dictate his will in front of a video camera and to record his so-called last will and testament. Of course, we Filipinos always respect the wishes of somebody who has died. But even then, that's not a valid will. The will must be in writing. Recall that under Article 804, the law is also categorical when it says, the will must be executed in a language or dialect known to the testator. The will itself must be in a language or dialect known to the testator. Therefore, if the will was written in English, but the testator did not know English, he knew only Filipino. But the lawyer who drafted the will explained everything to the testator. He translated it, he interpreted it to the testator completely and fully explained everything. That remains an invalid will. The law is not satisfied with mere translations, interpretations. The will must be in a language or dialect known to the testator. And there is a good reason for that. No matter how good the interpreter or translator may be, certain nuances of language are always lost in the process of translation or interpretation. It is not necessary, however, for the validity of the will that the will itself should contain a statement to the effect that it is in a language or dialect known to the testator. That is not required. Okay? So, if there is a dispute later on, the people opposing the probate of the will say, oh, this will is in English. Okay? The testator does not know English. If that claim is made, then that would necessitate the presentation of evidence. Evidence which can come from the outside, not necessarily from the will itself. So kung yung ganun na nangyari, the petitioner may present witnesses, neighbors and friends of the testator who will testify. Oh, that the testator actually knew English. He spoke English. Yeah? Especially when he's a little bit drunk. All words in English ang salita ng testator pag medyo nakainom. All right. That's admissible. Okay. Although, of course, if you're already lawyers and you're drafting a will, it would not harm if you include a statement in the will itself na no, all men may dispress, etc. I do hereby publish this, my last will and testament, in English, a language known to me. Okay yun. That will be quite helpful, but that is not necessary for the validity of the will. Okay? All right. Let's discuss the basic requirements for a valid notarial will. Okay. The basic requirements for a valid notarial will are found in Article 805 of the Civil Code. Okay. Every will, other than a holographic will, must be subscribed at the end thereof by the testator himself or by the testator's name, written by some other person in his presence and by his express direction, and attested and subscribed by 3 or more credible witnesses in the presence of the testator and of one another. All right. Let's stop. Paragraph 1 already tells us a lot. Okay. The first important thing which we have to remember in connection with paragraph 1 of Article 805 is that it tells us in very clear language one essential requirement for the validity of a notarial will. What is that? It must be subscribed at the end thereof by the testator himself or by the testator's name, written by some other person in his presence and by his express direction. The requirement, therefore, for subscription, for signing at the end of the will, is an essential requirement for validity. If the will is a 5-page will and the testator affixed his signature on each and every page of the will, on the left margin, nandun, page 1, page 2, page 3, page 4, page 5, on all of the margins, nandun ang pirma ng testator. But he did not sign at the end of the will, that is not a valid will because it fails to comply with an essential requirement under Article 805. The next question we have to ask ourselves is, where is the end of the will? Okay. When the law mentions the end of the will, it refers not to the physical end, but to the logical end. Meaning, after the last testamentary disposition. Okay? So, kung 10 disposition yan, if there are 10 testamentary dispositions, the end of the will is after disposition number 10. Sa baba nun, that is the end of the will. Okay? That is where the testator should affix his signature. The law, of course, allows the affixing of the testator's name by a third person. Pwede, that is permitted. But, remember the two requirements. It must be done in the presence of the testator, and it must be by his express direction. Okay. Both requisites must concur. Otherwise, the will is void. Okay. If the testator is Juan Santos, okay, and the person requested by the testator to write his name is Pedro Santiago. Okay. How should Pedro Santiago comply with Article 805? He should not forget to write the testator's name. Yun ang pinaka-importante. Because, ang sabi ng law, subscribe at the end by the testate himself or by the testator's name. So, pwede ang isulat ni Pedro Santiago is Juan Santos by Pedro Santiago. Pwede yan. Supposing that Pedro Santiago simply wrote by Pedro Santiago, hindi niya sinulat yung Juan Santos, that's not valid. Okay? Kasi maliwanag ang batas. Testator's name. Supposing that Pedro Santiago simply wrote Juan Santos, he did not bother to write his own name, Pedro Santiago, that is valid. Pwede yun. As long as in the attestation clause, the fact that Pedro Santiago wrote the testator's name in his presence and by his express direction is stated. Otherwise, if the attestation clause does not state the fact that Pedro Santiago wrote the testator's name in his presence and under his express direction, then the will is void. All right.